Welcome to Gavels Down, Voices Up with me, Rachel King. This is where we leave convention at the courtroom door and dive into your real stories, bold and unpopular opinions, and change-making ideas that really shake the legal world up and change where change is desperately needed. I'm here to shake it up, talk about unfiltered insights, and amplify voices that need to be heard. So are you ready? Let's get it. Put the gavels down and the voices up. This is Gavels Down, Voices Up, and I am attorney Rachel King, and today we are going to do part 2 of the substances, alcohol and marijuana in custody and visitation. In part 1, if you haven't listened to it, go back and listen to it. We talk a little bit about the law and how just because it's legal doesn't mean it's okay. It can still come in and affect your custody and visitation orders. I do think it's important, though, to start today by explaining that just because one of the parents or somebody comes in and says that there's a substance abuse problem doesn't necessarily mean that the court's going to change custody and visitation or that the court is going to order drug tests and all of that. That's not what I mean. What I mean is that the law requires that a court first determine whether a person is using a substance like alcohol or marijuana on a continual, frequent, or habitual use. If they're abusing the substance, it could be, again, alcohol, marijuana, or other controlled substances. And yes, even prescription medication that you are prescribed. So if the court finds that even with your prescription meds, you are using them continually, frequently, or are a habitual abuser of these substances, controlled, illicit, legal, whatever you're calling them, the judge can take steps to change custody and visitation or to order drug tests. Okay, so this has to be backed by evidence. I've had this many times, and I say this because I've done a lot of California family law cases and actually other state cases as well. And it seems that in most of these substance abuse cases, one person is saying that the other parent is using and abusing, and then the accused parent is saying, no, I don't. And we become a he said, she said. And all over social media, this is flying around about how it's legal, how marijuana is legal, how alcohol is legal. It's totally fine. It's no big deal. And so it shouldn't affect. But the bottom line is it does affect. Well, how in the world do we prove it? Certainly you can say, my goodness, I lived with the person for years and they smoked pot all the time. But then again, that becomes just a he said, she said. And I've actually heard judges say, well, if you didn't have a problem with the pot smoking while you were together, and you thought that other parent could be a great parent and you were comfortable leaving child with other parent while you went to the grocery store or went out with friends or even away for the weekend, I don't know why the court should all of a sudden be concerned about it now that you guys aren't together. You weren't concerned about it then. Why are you concerned about it now? And I've seen the court kind of struggle with what they should do with that. I've had parents say the reason I was okay with it is because I was there all the time. And so while they were smoking pot and I didn't think they could take care of the kid, I was there. I was the one making sure our child was okay and safe. I was the one that was making sure that other parent didn't roll over and hurt our child. But now I'm not there, and so I'm not okay with it. I get it. I totally get it. Man, do I get it? I could tell personal stories about it, but I'm not going to right now, other than to say, at one point, my husband was drinking far more than I thought was okay or was safe. And I, too, was like, okay, well, as long as I'm there, it's okay. Fortunately, in 2014, he stopped drinking entirely, hasn't had a drink of alcohol since, and we're still married. So that says a lot. But I get where you're coming from. Unfortunately, that's typically not enough evidence. So what are we looking for? I've used declarations and testimony from people that partied or saw. I've actually used testimony from people that provided drugs. I've used criminal records, of course, of arrests for DUIs or drug paraphernalia. I've used social media posts. And yes, social media is a big old mess, right? I have found through different cases that not only in social media can you use the person's personal social media posts. You can also use posts that other people have made and have tagged. In fact, one parent in a case that I was involved in, the other parent was seen in the background and was tagged or something and had a bong up to their mouth and was smoking pot out of that. And I was like, enough evidence, but everything else was private. This was just an accident. I guess her friend didn't understand the severity of the legal case and of the allegations, but that was evidence that was brought before the court. Drug tests. Sometimes you can get voluntary drug tests where you say, look, you say you're not using the drugs, then just take a drug test and then it comes back positive. So really you want as much evidence as possible to prove that it's going on now. I've had people take pictures of houses where you see all of the drug paraphernalia around. Really, you can use a lot. The big thing I would say is there has to be, if it's not immediately present, then you're going to run into the fact that was then and this is now and they don't use the drugs then. So you either want to show a consistent pattern where this has been a problem, but you also want to show that it's a here and now problem if you're trying to provide the evidence. And the court really should look at the here and now. We're not necessarily going to punish somebody because they're an alcoholic or they are a drug addict if they're in rehab, right? That wouldn't be fair. And in fact, we'll talk a little bit about that at the end. So here and now evidence is what you want, and you want as much as possible, right? To show that this actually is a problem. Some of the issues that we've had when we've had to look at these kind of cases and try and prove them is it's really hard to get friends to testify against the friends that they smoke pot with habitually, right? You're not going to get a drug dealer to admit under oath that he sells drugs. That doesn't quite work. So now that marijuana is legal, again, just because it's legal doesn't mean it's not problematic in custody and visitation. I would be interested to see if subpoenaing records for punch cards or any of these dispensaries that keep a record, if they have any of that, getting receipts if something like that would work, or if getting a credit card statement that shows a dispensary payment. I wonder if you could use that. You're still stuck with, is it habitual and continuous and problematic, or is it just like a Friday night, they don't have their child, so they're going to smoke marijuana? There's nothing wrong with that in many states because it's legal in many states. I've heard, though I don't know for certain, that even some of the states that it's not legal in, the judges are like, yeah, but it's about to be legal, so I'm not going to do anything about it. Anyway, here's some of the other evidence that might be used. If they've ever admitted it to you, like, oh, I can't come pick up the kids, I'm drunk, or I've smoked so much pot, go back and review your text messages, go back and review your voicemails, your emails, anything in writing. Anytime the person admits it, that's really, really good evidence. Medical evidence, if there's ever been an admission to a hospital to have stomach pumped, or they've admitted even in a doctor's office when they say, do you drink, how many times? It can be harder to get medical records just because of HIPAA, but it is certainly something to look at and consider. Again, we talked about eyewitnesses, but people that have actually witnessed it or participated in it with the alleged user, because you don't want to get into a hearsay situation. Any law enforcement involvement, right? We talked a little bit about that. That could be an arrest history. Police officers, maybe they didn't do an arrest, but they sent somebody home. I've had that case where the police didn't really want to make a big deal of it, but the dad was clearly under the influence when he came to pick up the kids at visitation. So mom called the police. Police came out. They didn't make the kids go with dad, but they didn't arrest either. They just said that somebody had to come and drive dad home. He wasn't allowed to drive that vehicle. But anyway, those police officers would be really great witnesses because though they didn't do an arrest, they were there. And then, of course, any CPS reports that are substantiated. CPS, people make allegations to CPS all the time. You're really looking for one that wasn't unfounded, but one that was substantiated. That means CPS did actually have enough evidence to say, yes, this happened. But maybe you don't have any of it, and it's just your word against his or hers. How you testify and how the other person reacts are going to be things that the court considers when they're looking at whether somebody has a drug problem or an alcohol problem for the purpose of custody and visitation. You would be shocked at how people's mannerisms, body language, facial expressions, all of it really gives away their credibility. And in fact, I have done a lot of videos on courtroom demeanor, but especially when you're dealing with an addict or somebody that is getting accused of doing drugs or having an alcohol problem, many times give it away with their body language. So a judge will, they already consider that, but they're definitely going to consider it when they're going through allegations of substance abuse or alcohol use because they're trying to make sure the kids are safe. That's really the bottom line. All right, so what does the court do? Maybe they order supervised visitation. Maybe they have safe zones for pickup and drop off. Maybe they again say no alcohol or marijuana use 12 hours before or during. Maybe they have some kind of breathalyzer. I've had people that have been alcoholics and have had serious alcohol abuse issues that have had to blow into a breathalyzer at the beginning of every visitation before they can start a car, all of those kind of things. Custody can be changed. It does warrant, if the court wants in certain circumstances, a sole custody situation, depending on, again, how bad the abuse is, what has happened, what kind of neglect or how has it affected the children, and whether it's necessary to keep the kids safe. I do think I should bring up here that just because somebody is a hardcore addict doesn't mean they're not going to get any time with the kids. It's the same with child abuse, right? I was actually in court. It wasn't my case, but I was in court and I watched a domestic violence trial where a dad was accused of abusing the children, physically abusing the children, and using drugs. That was one of the causes, I guess, of the physical abuse. And the court found, yes, domestic violence had occurred. The father had physically abused the children. The court found that there was substance abuse issues. The court granted a 3-year restraining order protecting the kids from dad, and then immediately after ordered supervised visitation. So keep in mind that all of this together, there's still this underlying philosophy that kids should really have a relationship with both parents. When we're looking at substances, specifically alcohol and marijuana and these other things, we aren't trying to necessarily remove that parent from the kid's life. We're just trying to set that parent and that child up for success so that they can have a safe relationship. No, dad, you cannot have visitation while you're high as a kite. Mom, probably best that you don't have time with your kids when you're passed out, drunk on the couch, drooling and peeing on yourself. Again, actual things that have happened.
And now for a quick break. This episode of Gavels Down, Voices Up is proudly brought to you by King Law Firm Attorneys at Law Incorporated. We're not just about winning cases, we're about making a difference. Whether it's family law, probate litigation, or standing up against elder abuse, we bring experience, empathy, and excellence to the courtroom. At King Law Firm, we're more than lawyers. We're your team, in your corner, advocating for your rights and making your voice heard. Visit us at thelawyerking.com and on the socials at The Lawyer King to see how we fight with you and for you. King Law Firm Attorneys at Law Incorporated, where your fight becomes our fight. Now, let's get back to today's episode.
You're not destitute, though. If you are the person that's being accused of substances, either because you actually do have a substance abuse problem or because you did or you had in the past, you're not totally screwed. Again, people are allowed to drink alcohol, even with their kids around. You can go to a barbecue and have a beer, or you can have a glass of wine at dinner. You can have a brandy at the end of the day or whatever. I don't drink, so I don't really know. But, your whiskey at nighttime to wind down. You can have all of those things. The issue is that you can't have them so often and so much that it's impairing your ability to parent. You can smoke the joint. You can smoke the blunt. You can have a gummy. It's okay if it's legal, but you don't want to get yourself to a point where you are so out of it that you can't hear your kids when they need you, that you are passed out and unable to care for them. If you get to that point, it's bad news and you're going to have everything. You could potentially have your child custody affected. If you're having these accusations made against you, you certainly want to, and it's not true, you want to be able to show that this is casual social use, that it doesn't impair your ability to parent. Again, character witnesses, all of the negatives. I've never been arrested. I've never gone to the hospital. I've never used this. Here's all the people that say I'm okay. That's what you want to use. And if you're trying to prove it, again, you're going to go into the opposite, all with both of you in mind, going through this, understanding that it's really about the kids. It's not about getting the children away from either parent. All right. But now you are an addict. You do have a substance abuse problem, but you are in treatment. There are definitely things you can do. And I've represented people that still consider themselves alcoholics, but they haven't had a drink in 20 years. I've represented people that have shown up in court drunk and then decided that they needed to make a change in their life. I've represented clients that have been clean for a very long time. And I've also had them that this is like a brand new cycle and we are working through it. And I always take the same approach with my clients that have a substance abuse issue where it is potentially going to affect their child custody. It changes, of course, depending on each specific case, but we focus on the now. Yes, there might be a history of abuse. You maybe had some DUIs and some arrests and all of the things that go along with it. But right now, as we stand here today, here's what I'm doing. I've recommended that clients have gotten themselves into rehab. Almost every single time, even if it's from a long time ago, but they're still saying that they're an alcoholic, I say, get yourself into AA or some kind of recovery program and keep a logbook of every time you go. Have somebody at that meeting sign off on it. That shows that you're participating in the recovery process. Certainly stop using if you haven't already. If you were a prior user and you've been clean or sober for a period of time, then we go back and show that. Like, yes, this happened. Last incident of using is 20 years ago. That was right before we had the DUI, but we have this extended long period of not using. Or, yes, I did end up in the hospital needing my stomach pumped 3 days ago, but as of today, I'm in rehab. I joined AA and I am not drinking anymore or using. I'm a big fan of not making excuses. I don't really think it goes over well in court when you're like, yeah, but I don't really smoke that much pot. It's just for medicinal purposes and it's legal. I just use it to sleep or unwind. It's not a substance. It's fine. It's not a drug. Or I'm just a social drinker. It's totally fine. I don't really like the excuses because it really opens up to the other people that are concerned to be like, really, you're a social drinker, but you ended up passed out every single weekend party night on Saturday, naked on a picnic table in the backyard while your child was running around trying to figure out where you were. Again, true story actually happened. So instead of making excuses for what's going on, again, I'm a big fan of just focusing on what we're doing right now and where you are. Certainly don't justify why one drug is better than another. And this is going to be debatable. Some people may think that I'm totally wrong in this, but I have had people, I didn't represent this person, I represented the other party, but they came in and said that had a heroin issue, right? So a recovering heroin addict that came into the court, not a hugely recovered, but like 8 months of recovery, came into court and the judge was concerned about the heroin issue and was trying to follow up. And the person said, I don't do heroin anymore. I just smoke pot and drink alcohol. I kid you not, the judge just said, do you think that's really a good idea? Like you give up heroin and you just start doing these other substances. Don't you maybe think that they're going to lead you back there? Listen, I'm not a shrink. I'm not a therapist. I am not a drug and alcohol counselor, but I can tell you that if a judge is concerned about you replacing one substance with another, you should be concerned about it if you're involved in a custody hearing, because it may be something the judge considers and doesn't like too much. Also, I've known people that have gone through treatment, and I don't think you're supposed to do that. But, prove me wrong. Or don't. Maybe just don't use the substances. I'm a big fan of recommending that my clients get into some kind of individual therapy. I think that goes a long way with the judge. If the children have been impacted, then getting into some kind of conjoint therapy. Maybe you've been out the life for a while because of some kind of substance use issue, and so you haven't really done anything negative to the child, but you haven't been there. I think offering conjoint therapy, participating in that can be really helpful to a child custody situation. And then again, staying on track. Whenever I handle a client that has a current drug issue that they're trying to work through for custody and visitation, or a previous one, I focus on the now, get into rehab, get into some AA or some kind of recovery program and keep a logbook or record book of it. Certainly stop using, own it. Don't justify why one is better. Get into therapy for yourself so you can work through all of the emotions that are coming and help improve your likelihood of ongoing success. Of course, get into therapy with your child so that you can heal that relationship. If none of this is possible without a court order, you tell the court you're willing to do it. I also think being open, though you definitely want to talk to an attorney about this, but being open to ideas that the court has to make them feel comfortable with your visits. Maybe the court says, I want you to take a breathalyzer before you drive the kids because you recently got a DUI with the children in the car. Or, okay, how about we just say no alcohol while you're around the kids? Well, if the other parent comes to drop off the kids and believes that you're under the influence, I'd like you to be willing to submit to an on-demand drug test. You don't necessarily need to agree to those, but sometimes it can be helpful because it's showing the court, look, you really are doing what you can and you're willing to take certain steps to prove that when you're with your kids, you are safe. And if you are one of the people that has lost their children to substances or is facing this, no, you are not alone. There are many people out there. Britney Spears lost her children in 2007, partly as a result of her substance abuse. Brooke Mueller, who was married to Charlie Sheen, lost custody of her children because of substance abuse. She also ended up getting them back because two wrongs don't make a right? So dad had substance abuse issues in 2013, and so he ended up losing custody, going back to mom. Courtney Love lost custody of her daughter in 2009 as a result of her substance abuse issues. Janine Lindemudler, she's a pornographic artist, so maybe that's why I cannot pronounce her name, but she had a substance abuse issue and also lost custody of her children. That may be because her children had a strong stepmother named Sandra Bullock to be there. But in any event, she did end up losing custody because of substances. Lisa Marie Presley lost custody due to substance abuse. Mama June, I think we all know her from Honey Boo Boo. She lost custody in 2019. Amber Portwood is the Teen Mom star. She lost custody. Here's a kicker. She lost custody because of substances because she wrote a book that she published where she admitted to substance use. So be real careful what you're putting out there. But in many cases, it's really important to remember that no matter where you are, there's a lot of help out there. The court wants to help you. They want you to get to a place where you are safe for your child. And there really is this underlying belief that a child should have both parents. And so how do we get them both parents in a safe and healthy way? This is all about substances, custody, visitation, alcohol, marijuana. And I hope the takeaway is one that just because it's legal doesn't mean you should. And just because somebody says you can doesn't mean you should. But also, if you are faced with allegations, true or not, of substance abuse, it doesn't necessarily mean that you are destined to never have any time with your children. There are things that can be done. And really the goal is to keep your children safe when they're in your care or anybody else's. My name's Rachel King. I'd love to hear your stories or hardships. I know many people are out there right now facing and going through these really, really difficult custody battles. So share your story. We'd love to hear it. We'd love to offer support and guidance. And until next time, gavels down, voices up. Thanks for tuning in to Gavels Down, Voices Up. Like what you heard? Then don't just sit there. Subscribe, share, and tell me your thoughts. I'm Rachel King, bringing not just my opinions to the mic, but about the courtroom too. Your part, keep listening, keep engaging, and until next time, let's keep those gavels down and our voices up. Unmistakably up.